As the parasha states, you shall appoint magistrates and officials for your tribes and all the settlements that your God Adonai is giving you, and they shall govern the people with due justice. You shall not judge unfairly. You shall show no partiality. You shall not take bribes, for bribes blind the eyes of the discerning and upset the plea of the just. Tzedek, tzedek tirdof. Justice, justice you shall pursue, that you may thrive and occupy the land that Adonai is giving you. A single witness may, continuing from the Parsha, a single witness may not validate against an accused party any guilt or blame for any offense that may be committed. A case can be valid only on the testimony of two witnesses or more. If someone appears against another party to testify maliciously and gives incriminating yet false testimony, the two parties to the dispute shall appear before Adonai, before the priests or magistrates and the authority at that time. The magistrates shall make a thorough investigation. And if the one who testified is a false witness, having testified against a fellow, then that one should receive the punishment that was intended for the other. We take for granted in many ways due process and the system of two witnesses, and Masechet Sanhedrin is not alone in an extensive discussion of the Talmud, as well as centuries and centuries of commentary for what these words mean and how they can be employed, and whether they don't just apply to criminal cases, but also apply to other disputes between people. In many ways today, we take for granted the integrity of our legal process. We take for granted the presumption of innocence. We take for granted that those investigating and judging, Shoftim v'Shotrim, gang of the Parsha, two separate groups, just like Law and Order, they based it on us, that the two separate groups of those investigating the crimes and those who are judging the crimes will abide by due process. The Parsha can seem like, at most, a reminder that the Torah also held these values, or maybe we're an important source for the heritage we take for granted in the West, and we can be proud. But I believe we've seen an erosion of these core principles. And I think a pact we see or observe has been broken in our society. You don't have to keep the rules of that which is defined by your role. And it's not just investigators or not just judges. It's anyone who takes an oath, anyone who holds a title in so many ways. So I want to extend it beyond even those two groups, certainly including me. If you are serving a greater end, there's an creeping sense that whether you keep the exact due process or exact rules that you took an oath for or have an implied oath for, that might be good to achieve larger ends. I actually see people quoting that the ends justify the means, and they're not being like ironic. You know, they actually are like, well, you know, the ends justify the means in some cases. I'm like, no, like that was the whole thing we did in ethics, to say the ends don't justify the means. So it's kind of strange to hear. It's increasingly promoted. If you are a lawmaker, you don't have to make laws you know are good, if it might lead to the other party benefiting from the victory. If you are a political party, seems all right to put significant resources toward very much praising an abhorrent candidate from another party, if it benefits the larger political calculus of larger political primary and other gains in the long run. So our role is to promote what we believe. We're going to promote what we don't believe, because in the end, it'll ultimately get back to what we believe and justify the means. And if you are an administrator, you might overlook individual facts in order to rectify larger societal issues that are really, really important and serious. I once gave a sermon. I'll just quote the nafka mina, the end moral. I'm very influenced by Sforno's commentary on tzedek, tzedek tirdof. Why do you have to emphatically pursue justice? And what Sforno says is that when you hold an office, it is an act of free will to pursue justice in your position. So that the way I understand him is to be saying, just because I have the title rabbi doesn't mean I really have to keep the implications of what that means. And just because someone has a particular role, it would be an act of free will to make sure they stick to their role in the process, rather than have a creep of other values or rectifying other forms of injustice. Of course, the whole parsha is really about ending vigilante justice. The issue of that there are legitimate reasons to seek rectification of past injustice, and that can't cloud the partiality of those who are making those decisions. So tzedek, tzedek, yeah, you have to, and of course it relates to the king in the parsha, where the king actually has to study. Why does the king have to study the Torah all the day? And it may just be the part of the Torah that talks about the king. It's because the king has to be reminded that, like, you have to, Sforno says, you actively have to choose to keep that part. It's not like necessarily people would be forcing you to. You probably well know, and I'm not going to say anything too profound about it, but I can't help but feel like the parsha is asking us to consider the fact that this is not ancient history. Like, oh, we have this heritage of due process influenced the Enlightenment. Of course, everything before the Enlightenment, they were all barbarians anyway, the terrible mistake of some historical bias. But it's actually very, very relevant today because the Department of Education, under multiple presidents and university administrators, are under tremendous pressure and good pressure to figure out how to rectify incredible amounts of past injustice. I said I wouldn't be too explicit. I'm trying to be, but you know what I'm talking about. Incredible invasions of human dignity and past injustices on campus. So what's been going on is not okay. But then how do you create a system that works and brings justice without the temptation to do so in a way that, in the name of rectifying past injustice, is not careful about the procedures that are written? So some procedures are written by one administration, then another administration writes new procedures, then another, and I don't even know what college administrators and Title IX offices have to deal with. I can't even wade into that. I feel for them. I read one extended essay by a Title IX official at a major university that talked about how incredibly difficult their job is because of the extensive set of the kinds of things that are brought to their attention. So what procedures do they follow? Do they demand 2 witnesses instead of 1 witness? Is it the case that in order to rectify past injustice or in order to protect victims, they may not have to testify? They may not be subject to cross-examination. And we have the parsha saying, look, you need someone to be able to say in some way, I'm not talking, like, try to get out of your mind for a second, a court of law, and someone is brought up to the stand. There are other ways there could be ways for witnesses to testify not in the presence of their accuser, and victims not to have to testify. But in many cases, based on some regulations and some understanding of them as they keep getting rewritten, so I can't keep up, sometimes it's the case that victims don't have to issue a statement at all. And what the rabbis understand, among other things from the parsha, is at some point people have to say, I swear to God that what I'm saying is true, right? That act is incredibly important. It's one of the 10 commandments. When we're talking about not taking a vain oath, we're talking about that oath. I mean, we still have it today, right? I swear to God that I'm telling the truth now. Now, the rabbis know people lie, and I'm going to get to that in a minute. But at least, like, that is required. So, and witnesses. Can we base things on one witness? When, as the rabbis point out, so often when you have a single witness, injustice can take place. In a very interesting article published by, well, actually, she published 4 of them, by Emily Yaffe in The Atlantic and in Common Sense, she points out that, the new Title IX regulations, 701 pages worth, that the Biden administration released, is again changing the due process college students who are accused of sexual misconduct will go through. And there is no question, she writes, and I absolutely agree with, that there is deeply wrong, sometimes criminal, but even when not necessarily criminal, there's wrong, injustice, and lack of protection based on the behavior that is occurring on college campuses and has. And we have to eliminate it. And that has to be our goal. That has to be pursued, tzedek, tzedek, tirdof. And that is long overdue. But how do you tzedek, tzedek, tirdof that, she points out, without violating the very rules of tzedek, tzedek, tirdof? The new rules recommend a return to a single investigator model that was previously barred. So the shotrim and the shoftim can be the same person. The investigator, who may develop a bias even unwillingly in the process, then is the same one deciding the case. One administrator can act as a detective, a prosecutor, a judge, and a jury on a Title IX complaint. And the new rules also undo many of the procedural protections for the accused, including the right to see all the evidence, including inculpatory and exculpatory evidence gathered against them. Young men suspended or expelled have filed civil suits against their schools for fair treatment, over 675. And I actually believe in the last article I read, we're up to 770 and above. That's a lot of cases filed in court saying, I was deprived due process on campus, except for the fact that on campus, we're not talking about criminal courts. We're talking about schools trying to prevent injustice through the codes of behavior that they have a right to expect on their campuses. So let's not pretend these are criminal courts, but do they still require something that the Torah is demanding? In the pursuit of justice, they have to be careful not to violate the oaths, not to confuse categories that we have to demand of ourselves. Of those that have worked their way through the system, judges have issued hundreds of rulings condemning those processes as problematic. And I have some quotes about that, but I'll skip them. So one of the things that has not been paid attention to, at least I wasn't aware of it as much, is that Title IX harm investigations have not hitherto recorded race. Amy Ziering, the producer of The Hunting Ground, a 2015 campus sexual assault documentary, has said the following. In a radio interview, she asserted that her movie was there to expose privileged, well-off white men. And she made her movie to challenge dominant white male power. But when you actually watch the movie, 3 of the 4 main stories were focused on assault allegations against accused who were Black. In a 2015 Harvard Law Review article, Trading the Megaphone for the Gavel and Title IX Enforcement, it is written, American racial history is laced with vendetta-like scandals in which Black men are accused of sexually assaulting white women, followed eventually by the revelation that the accused men were not wrongdoers at all. Mourning after remorse can make what seemed like a good idea look alarming in retrospect. But we have to be careful about the ways this is viewed depending on who the perpetrator is. Title IX director at Harvard said, quote, case after Harvard case that has come to my attention, including several in which I played some advocacy or adjudication role, has involved Black male respondents. One of the things they point out is often on campuses, people who did not socialize with people of other races and other ethnicities do so on campus. And often that leads to experimentation and to relationships that then come to seem problematic. In one case, a student was, things happen where a student was thrown out of university after freshman year, lost their scholarship, was thrown out of ROTC. And what came to light after the decision had been made was that the issue had been, and it was shown in a text, that he was not allowed to, was not taken into account by the 3 people that adjudicated him, was that this was done so that the person did not have to tell her boyfriend that she had cheated on him. So an accusation was made. This kind of thing goes back in history in this context, right? So that it's easier to say that. How does that evidence get introduced, right? I'm not saying it happens all the time, but we have to be aware of when we're trying to seek justice in one way, are we allowing injustice in another? Black athletes are commonly accused of sexual assault, and in many cases are exonerated later after they've been ruled against. New regulations do not require, sometimes, that the accused themselves make the accusation. So if the accusation is made and shared with another, the other person can bring the accusation so that the victim does not need to step forward. In some cases, and one I was going to tell you, but I don't want to get into details, 2 of the 3 people on the panel who made the decision of guilt admitted they did not read the investigative report at all. So let's go back to the Jewish part here. A single witness may not validate against an accused party any guilt or blame for any offense that may be committed. And we have the basis here in Jewish legal system, which notes the problems of a single witness. But unfortunately, in cases of this injustice, often you only have a single witness. Not always, but sometimes that's the case. And the halacha demands accusers appear in some court to testify. I swear to God that what I'm saying is true. And judges cannot show any partiality. So I want to share a teaching from the Talmud that maybe gives us a way forward and maybe not, at least a way to start thinking about the issue. And it comes from Tractate Sanhedrin 32b, where the rabbis give 4 different interpretations of tzedek, tzedek, tirdof. The first one comes from Resh Lakish. It says the doubling of the word justice indicates that the verse refers to the extra care a judge must take when judging a case in which one of the people testifying is lying. So if you know you've got a case where you got one versus the other, and you know one, maybe not consciously or whatever, one is lying. They can't both be true at the same time. That's why we have to be extra careful. Tzedek, tzedek, tirdof. The second teaching, it's a baraita, it's a previous inherited teaching quoted by Rav Ashi, says the first mention of the word justice, tzedek, refers to judgment. In other words, the decision of the panel, of the Beit Din. But the second mention of tzedek refers to compromise. That is, in many cases, or in some, it is not possible for a judge to reach a clear decision in favor of one party. That's quoting directly from the Talmud. And in such a case, a judge may need to seek compromise rather than deciding between the two. And I've never thought of tzedek, tzedek, tirdof that way. Think of it as instead of justice, you must pursue. Justice, sometimes compromise. And sometimes a middle way, because it's not always binary. It's not always, I got to go 100% you, 100% you. And maybe this is a way to think forward in terms of getting out of a dualistic thinking. And the third teaching, the Baraita says, it means tzedek, tzedek, tirdof, that we really have to search out the best available court. And sometimes the court that is closest is not the one that is most professional. These incidents have to be investigated. We have to have testimony. We have to have promising under oath. We have to have investigators. We have to have judges who are impartial. We have to choose tzedek over bias. We have to pursue the issue that one may well be lying. And sometimes maybe we have to choose a compromise, perhaps even at the expense of what really happened. Shabbat shalom.